I really want to share with you. First was a post that my associate actually sent me. Out of control. They apparently some people are getting their adjustment of status cases denied based on the applicant having entered the United States on the U4U parole program. Officers claiming that U4U is unconstitutional, so it's not real parole. And so it's like crazy, the extra work that you got to deal with. So they're denying those cases. And once you're denied, you might be NTA'd. The reality is, I got to see what actual claim they're making. That's what people are posting. But it's a matter of Kelantan. If you had lawful entry, you had lawful entry. Marry a U.S. citizen, you adjust. They could have told. So it's craziness. And so ideally, it'd be a lawyer that could argue with them, ask for supervisor, and say, matter of Kelantan, lawful entry, lawful entry. It is what it is. Now, they had this special TPS parole where they said, if you have TPS and you leave and come back, that is not considered parole for TPS. What was the thing about that? The Supreme Court said it too. You can't use that for parole. They had it for a brief period of time where if you were given TPS, even if you enter without admission, they would consider that TPS as kind of like parole in place and consider it as a lawful admission. And the Supreme Court said that's not the case. They created that new TPS travel permission, which makes up, it's like DACA AP kind of thing. So you get in. I had a new student come to our marriage green card course, a family-based green card course. They were listening a long time to the podcast before they pull the trigger to switch to immigration to get the course. And they said, yeah, I couldn't understand half the stuff you're saying because I use acronyms, DACA, TPS, DACA AP, this and that. And I was like, this is a trade podcast for people that are in the business, but we have courses and listen to our stuff.